Okay. Since Mr. Powell's here, we can begin. I don't know where everybody else is. Y'all bow with me. Gracious Heavenly Father, again we come asking you to forgive us of our sins, to say thank you for the many wonderful blessings that you give us individually and as our families. The blessings, the gifts, but most of all, Lord, thank you for being there for us. Keep your hand on us. Let us do things that please you. Remember to make us mindful that what we do affects a lot of folks. I ask these things in my Savior's name, Jesus. Amen. Mr. Jacobs.
Good morning, Mr. Chairman, members of the Rules Committee. I bring before you today House Bill 979. It's under the modified structured rule. As you'll recall, a few years back at this point, we adopted a law that requires certain boards of education to shrink from 9 members to 7, to not more than 7 members. This really affected the way that law was written, DeKalb and Rockdale counties. We now are facing a situation where the effective date of that law is the upcoming term of the school boards that it affects, January 1st, 2015. We are less than 2 weeks from qualifying without a 7-district plan being adopted for the DeKalb County School Board, which right now has a 9-district plan. The saving grace in our 9-district plan is that it has within it a plan for 7 single-member districts and has 2 super districts that encompass half the county each. And so all the bill does is divides that redistricting plan, does away with the 2 super districts, and preserves the existing 7 districts. As you know, our school board made headlines about a year ago because we were put on probation. This is the option that I believe best preserves the status quo. The governor replaced 6 of 9 members of our school board. And this is the option that best preserves the status quo in my view, and it's absolutely necessary because we are so close to qualifying. We do not have a plan that complies with the general statute, and we do not want confusion at qualifying.
Any questions? I've got all kinds. Ms. Hughley.
Thank you, Mr. Chairman. In the absence, to the author of the bill, in the absence of us doing something, what happens at qualifying?
I think the answer is confusion. You have a general statute that mandates a 7-member school board and a 9-district redistricting plan by local act. And the 9-district redistricting plan does not say within it that it, then later on complies with the general statute. It is simply a 9-district plan. So this will make clear that what we move forward with at qualifying are the 7 districts.
Minority Leader.
Thank you, Mr. Chairman. Chairman Jacobs, was there a conversation with the school board and with the school superintendent about your proposed change to the legislation?
The school board had a meeting and ended up wanting to stay at 9 members, but if they can't stay at 9 members, then they adopted some tweaks to the existing 7 districts. The real problem is, and let me also be very clear about this, I would have preferred that this be done via local legislation. I don't want to be here on a general bill that addresses this subject matter. But the fact of the matter is we have 5 legislative days after today, which is the minimum amount of time it takes to pass a bill. 5 legislative days remaining prior to qualifying, and this is the option that will clarify what the law is and best preserve the status quo. It preserves 7 districts exactly the way they exist today.
The thrust of my question is, given that we've just emerged from the confusion that led to, or not confusion, the challenges that led to the concern about our SACS accreditation, did the superintendent have concerns about this bill or this action having any effect? Because we are not completely clear of accreditation watch. Is there any concern from the superintendent about what impact this would have?
He has not expressed any concern to me.
Ms. Drenner. I take it y'all understand that Mr. Jacobs came from the Wendell Willard School of Brevity. Is Paul Battles in the room, or is he just a twin?
And Mr. Chairman, the next time I am here, I will pick.
That's enough.
I'll choose a new school of brevity.
I was talking about brevity, and you keep on. Bye. Mr. Bruce.
Good morning, and thank you for allowing me to come this morning to present a bipartisan effort in House Bill 704 to allow the residents of South Fulton County to decide whether or not they want to incorporate into a city or not. This will be the second time that this has happened. Back in 2006, there was an opportunity. A lot of things have changed since that time, and we have reason to believe now that the citizens would like to have this opportunity to vote to determine whether or not they want to become a city. If this legislation moves forward, the date would be May 20th election, and so time is of the essence to try to give these people an opportunity to prepare and learn all that they can learn about the options of cityhood or not. Thank you.
Any questions? Got a question, hold on. Ms. Jones.
Thank you, Mr. Chairman.
Y'all excuse me 1 second. Richard, do you know where we are? All right.
Representative Bruce, is it true that this is the last remaining unincorporated area, and by remaining unincorporated, they do not receive a per capita share of the lost 1-cent sales tax, and this would entitle them to receive that share locally, a tax that they do pay?
That is absolutely correct. It would give them a chance to, as I said, this is the last part of the county that would be incorporated. So it would give them an opportunity to play at the same level as the other cities in the county.
Mr. Lindsay.
Thank you, Mr. Chairman. Is it not true that for those of you who are tired of squabbling in Fulton County, this is one Fulton County bill that enjoys broad bipartisan support? Absolutely. Everybody is on board, so thank you. so
Thank you.
Could I get to vote it out today?
Thank you.
Thank you.
Mr. Duncan.
Thank you, Mr. Chairman and fellow members of the Rules Committee. I'm here on HB 749, which you'll find under the modified open rule part of the calendar. This is the Cargo Theft Act, Georgia's third in the nation in cargo theft. We've got a tremendous amount of interstates. We've got a lot of warehouse and distribution centers here because of our geographic location, and we've got the ports. This bill takes head on these sophisticated criminal groups by toughening the laws against cargo theft. It also correlates the penalties based on the value of the cargo. It arms the local law enforcement with additional tools to combat these criminals, and it gives the GBI original jurisdiction because most often these crimes are performed throughout many counties and over a very wide timeline. And so the industry and local and GBI feel like this is the best way to move forward to be able to stop these criminals. With that, any questions that you might have?
No questions, thank you. Mr. Efstration. Do I do that right, Efstration?
Yes, sir. Perfect. Thank you. Yes, just call me Chug. Yes, thank you, Mr. Chairman and members of the.
Have you been here before?
No, sir, I have not. Mr. Chairman and members of the Rules Committee. Yes, sir.
Okay.
I bring before you today House Bill 770 under the modified open portion of the calendar.
You know you're not supposed to talk when I am.
Oh, yes, sir. Yes, sir. I see, Mr. Chairman. Yes, sir.
I had some witty little remark to make there, and you've made me forget it. Okay, ready to begin.
All right, thank you, Mr. Chairman. House Bill 770 is under the modified open rule portion of the calendar. Members of the committee, this would create a new criminal offense of home invasion in the state of Georgia. There would be 2 tiers for the new criminal offense: home invasion first degree and home invasion second degree. It would serve 3 purposes: to isolate the most serious of offenses, which currently aren't isolated under existing burglary law. It's consistent with the governor's criminal justice reform and the work of the commission to isolate circumstances of property crime, to adjust parole guidelines accordingly. And finally, would serve the purpose of giving consistency. Existing burglary law doesn't distinguish between dollar levels of theft. This bill would provide penalties for perpetrators that enter an occupied residence while armed to commit a violent offense, either felony or misdemeanor, according to the tiers. And I'm happy to answer any questions, would ask for your favorable consideration.
The minority leader.
Thank you, Mr. Chairman. Representative, one of the concerns raised about this bill is the fact that actually contrary to the findings of the Criminal Justice Reform Commission, it sets in place on lines 27 through 28 mandatory minimums, and in lines 29 through 32 remove any discretion from the judge to probate a sentence, even if he finds or she finds the circumstances to warrant probation. Can you speak to why we would remove discretion from a judge, since we've been moving in the direction of restoring discretion to judges given the heavy sentencing that's mandated by this bill?
Respectfully, Leader, first of all, the discretion would exist to probate the offense for second degree, home invasion second degree. And I would argue that the governor's criminal justice reform and the legislation passed by the General Assembly left in place many mandatory minimums that exist for armed robbery, kidnapping, other serious felony offenses. And at the committee level, there was discussion of the fact and testimony given that mandatory minimums are not contrary to the criminal justice reform which was put in place. The important aspect is to isolate the most serious violent offenses, to only have the mandatory minimums in place for those offenses.
Thank you. Can you give me an example of a second degree offense that would not be subject to probation? I'm sorry, a first degree offense. The first degree offenses are not subject to probation. Can you give me an example of a circumstance that would warrant that treatment?
Certainly. The elements are: the perpetrator enters an occupied residence while armed for the purpose of committing a forcible felony. So as a prosecutor, I've seen many cases where a perpetrator is armed with a deadly weapon, kicks down a door to a residence in order to rob the person inside, and maybe does or doesn't actually effectuate that offense once inside. But this bill would make a felony simply by entering for that purpose.
And that would be a first degree?
Yes, that would be a first degree. To commit an armed robbery once inside?
Okay, thank you.
Mr. Rice.
Yeah, thank you for bringing this bill. The only question I had was the definition on line 22 or line 16 of likely to. In other words, it seems like it's a term of consideration in terms of who the observing person is, in terms of whether they're likely to or not. I haven't seen this before. So.
Yes, sir. That language was specifically inserted in the committee substitute, and it is taken from the aggravated assault statute that's already in place. This is to provide a broad definition for potential weapons. Media reports recently included a perpetrator attempting to enter with a shovel. And so in an attempt to have a broad basis for potential weapons, the committee, by amendment, elected to include this language, as I said, taken from the aggravated assault statute.
Thank you.
Thank you, Mr. Chairman.
Ms. Ballinger.
Mr. Chairman, Rules Committee, I come before you on HB 911. It's about 2/3 down on the front of the page, crimes and offenses relating to strangulation. Basically, this would be in addition to the current aggravated assault statute. This is basically a codification of current case law that would make it a felony to impede the normal breathing or circulation of blood of another person by applying pressure to the throat or neck of such person by obstructing the nose and mouth of such person. Hopefully, it is hoped that this will save lives. Over 2/3 of the victims that currently enshrined in our domestic violence shelters report to have been strangled, and once you've been strangled, you are 8 times more likely to be killed.
Questions? I got one.
Sure.
Strangulation by hand. How's that?
The bill would specify with any object, device, or instrument which, when used offensively against a person, is likely to or actually does result in strangulation. So the hands would be applicable, a belt would be applicable, and current case law does state that hands have been found to be deadly weapons.
Any other questions? Yes. Mr. Weldon.
Thank you, Mr. Chairman. To the lady, the acts that this covers and criminalizes. Mm-hmm. This is arguably already covered by current law, where it would be a battery, aggravated battery, and that, just to mention a couple. Mm-hmm. How does this improve the law where we are from where we are right now? I guess
by codifying current case law, it is hoped that this, by enshrining this in statute, it will serve as a public policy tool and also a teaching tool to law enforcement. A lot of times what's happening right now is because whenever somebody is strangled, they'll actually leave red marks on the throat of the person. So a lot of times that will actually get prosecuted as a battery, and it's not until they're actually sitting down with the assistant solicitor that they realize that it should have been charged as an aggravated assault. So hopefully this will allow for even prosecution throughout the state.
Thank you.
Mr. Golett. Where's that?
Thank you, Mr. Chairman. I was temporarily distracted, but to Mr. Weldon's question, and this came up in committee, part of the impetus for the bill is that courts have had different interpretations of whether or not the actual act of strangulation, the hands can be a tool for purposes of ag assault, and so this is
a codification.
Goes ahead and clarifies that once and for all, since we have a disparity in opinions in courts around the state. Is that not true?
That is true.
Okay.
Thank you, Mr. Williams. I'm getting ahead of myself. Mr. Williams.
Thank you, Mr. Chairman. I bring to you House Bill 790 under modified structure on the reverse of your blue sheet. This bill addresses the issue of timber theft, how we deter it, how we investigate it. It comes out of a study committee that Chairman Willard had over the off-season that included representatives of industry and law enforcement. It has several provisions. A key provision that I would point out to you, Mr. Chairman, in the interest of time, is it would empower the Georgia Forestry Commission, the state forestry agency, to investigate timber theft. The Forestry Commission already has post-certified officers who can investigate forest arson. It would add timber theft to their ability to investigate, to supplement and assist efforts of local law enforcement. I'll entertain any questions.
Any questions? Thank you.
Thank you.
Mr. Albert.
Thank you, Mr. Chairman, members of the committee. I'm working on Senate Bill 207, which is under modified structure rule on the second page. You were kind enough to allow this to go to the House floor last year, and we missed the clock on sine die. Quick review, this bill helps out those who are having in-home health care, that if someone's coming to your house to provide services and they've committed crimes, that they would be flagged if they have the First Offenders Act. It's not that we don't want anyone in the First Offenders Act to continue to work and get a job at Walmart or McDonald's or Home Depot, but we do not want to put them in the same environment, similar to the way we handled that today for schools and nursing homes and other such areas where they're most vulnerable.
Questions? Thank you.
Thank you, sir.
Mr. Barr.
Thank you, Mr. Chairman, members of the committee. I am on the back page, modified structure. This came out of the Child Support Commission, whom there are distinguished members, Court of Appeals, Superior Court judges. Thus, I'm not sure why I'm on the committee. However, this bill seeks to correct language and clarify some definitions. I'm sorry, it's bill number 701. Apologies.
Hold on. Mr. Earhart.
Thank you, Mr. Chairman. Representative Bars.
Yes, sir.
Having served for 5 years on the commission, I'm familiar with their work and have a great deal of respect for Judge Abbott and some of the others. I have a few questions for you. You should make some clarifications. It seems that you've made a substantive change to the rebuttable presumptions section throughout this statute. Can you give me an idea why we're going away from that, or why we're modifying it, I guess is a better term?
Sir, if you would help me out, and what
look at line 21
lines?
on page 1. You've changed you've struck through this amount is rebuttably presumed to be the appropriate amount of child support, and it's a thread that runs throughout the legislation. There's some significant change to that. I'm not saying I'm adverse. I want to understand the thought process before that. As much as I respect that group, I don't want to cause a hearing, Mr. Chairman. How about I talk to Representative Bars?
Let me make a suggestion. Mr. Barr, I would think it would probably be a very good idea for you to meet with Mr. Earhart and kind of go through that, because he has a lot of knowledge on that bill since he's been involved with it for about 7 years or something. So I would suggest
yes, sir.
That would be the thing to do.
Very good.
All right. Thank you.
Thank you.
Mr. Fleming.
Thank you, Mr. Chairman. If the chairman would allow, I'd like to bring to the attention of the committee 2 measures this morning. The first one is on your first page on a modified open, House Bill 670. House Bill 670. Mr. Chairman, members of the committee, this is an effort to continue to bring to the citizens of Georgia, through an electronic fashion, all the records that are available in the courthouse that our clerk of court keeps. Through the years, and this specifically deals with only trade names, through the years we have slowly made available online to citizens records in the courthouse that they don't have to go down and search themselves for. We started with UCC filings, and then we went to deeds. One of the last things that's not online that a citizen can't get to is trade name registries. That's where Barry Fleming, for example, wants to open a business, but I'm going to do business as somebody else, Barry's snack shop, or whatever you want to call it. I have to register my trade name so that the public and everybody else will be a record of who that is behind that business. This simply, Your Honor, would say that when you go register it, you pay a $5 fee like we've done every other effort to get these records online, and then it would be online for anybody to search.
Next bill.
Next measure, Mr. Chairman. Okay. Mr. Chairman, the next measure that I would bring to you is on the second page under modified structure, House Bill 891. House Bill 891. Mr. Chairman, this deals with early voting for only our cities in the state of Georgia. The Georgia Municipal Association has asked now for a number of years to please do something to help with the cost to our local governments, only in the form of cities, for what it costs them to put on early voting. They got some help a few years ago when we took early voting from 6 weeks to 3 weeks. This is their request to bring it down to 1 week for cities only. It does not affect county elections, state elections, federal elections, but cities only. We treat cities differently already. They are only an odd number of years, city elections. They're all nonpartisan. We don't have any Democrat or Republicans on the ballot. And like I said, this is a strong request from GMA. And this bill takes it from 3 weeks to 1 week. It's for cities only.
Ms. Abrams.
Thank you, Mr. Chairman. Mr. Fleming, was there any conversation with or any consideration for large cities like Atlanta that have longer periods because there are limited places for voting, especially because voting occurs in 2 separate counties? Was there any conversation or hearing or testimony from those larger cities and about the impact this could have? Because the way I read this does not provide any flexibility for any larger city that would like to have more than 1 week of.
Madam Leader, in answer to your question, that no one at subcommittee or hearing testified to anything that you're mentioning. GMA did testify exhaustively how they have worked for years on this with all their cities, and it comes as a, I won't say unanimous, but close to unanimous as you can probably get with the city's request for this. So the answer to your question is nobody brought that up.
Would you be amenable to a conversation, because I have heard from larger cities that are very deeply concerned about the constraints that this would place on them, and that during the time of the subcommittee hearing, it was during the snowstorm, so they weren't able to attend the hearing, and they weren't able to make the rescheduled hearing. And so would you be amenable to having a conversation? Because for larger cities, this does place a fairly strong burden on them. The majority of our cities in Georgia are actually smaller cities, but fairly large cities would find some substantial impact being restricted to a single week.
Madam Leader, I certainly would. I said a minute ago that there was no discussion. There actually was discussion that this is not going to at all affect absentee balloting. You still have 45 days to do that, so there's still a very large period for voting. However, had anybody brought that to me, I certainly would have looked at it. We're late in the process now, as you know, on the House side. Of course, it's got to go to the Senate, but I certainly would entertain any proposal somebody had and talk with anybody about it.
Thank you, sir.
Thank you.
Ms. Dempsey? No, Mr. Peake, I'm sorry.
Thank you, Mr. Chairman. Representative Fleming, real quick, how does this affect the handful of consolidated communities we have?
Good question. It does not, and here's what Legislative Council and GMA both said. In order to encourage consolidated governments in our state, we give them a lot of flexibility, and they actually get to choose if they want to be treated like a county or treated like a city. So for several of your major cities in Georgia, Augusta, Macon, Columbus, Athens, they can choose to follow this if they want, but they don't have to.
Okay, but it will be the choice of the
That's what Legislative Council and GMA both said, yes, a choice for the consolidated governments.
Thank you.
Thank you, Mr. Chairman.
Mr. Brockway.
Thank you, Mr. Chairman. Second page under modified structure, bring before you House Resolution 1215. It's a call for an Article 5 convention for limited topics, and the topics are described in the paragraph beginning on line 17. So it would impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit terms in office for officials and for members of Congress. So that's the measure, and I'll be happy to answer any questions.
No questions. I'm going to change the rules a little bit here. Mr. Calstert, you be next.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman, members of the committee. I bring before you Senate Resolution 371. It's under structured rule on the back page. It is also an application for an Article 5 convention. It is for the limited and specific purpose, though, of proposing a balanced budget amendment. That's all it will handle. Differs somewhat from Representative Brockway's that asked for 3 general topics. His asked for fiscal restraints, limitations on federal power, and limitations on terms of office. That, I think, came out of the Convention of the States movement, which is based on Mark Levine's book, The Liberty Amendments, which calls for about 11 different amendments to the United States Constitution. That's a little bit similar topic issues, but it's more of a shotgun approach trying to get those broad areas. This is a rifle shot. It is only a balanced budget amendment, and that's all it calls for. There are 20 states that have passed either identical or very, very similar amendments to this, which I believe is why it's under structure rule. It needs to stay the way it is so that it'll be uniform with the other states. Of course, it requires 34 states to call for the convention. Georgia would be the 21st state. And I understand Wisconsin either voted yesterday or may vote today on a very similar measure. I also have Senate Bill 206 up under modified structured rule on the same page. That is essentially enabling legislation for this. It's referred to as a Delegate Limitation Act. What it does is set forth the mechanisms how Georgia would appoint delegates to an Article 5 convention, and it very greatly limits their participation in that convention, so they would only be able to consider topics under the application that we submit, in this case, a balanced budget amendment. And it requires them to follow any other instructions given by the legislature, any legislative instructions, so we would be able to tell the delegates what their scope of authority is, what they may consider, what we're looking for to do. If they were to violate the terms of that and broaden the scope of the convention, you hear the fears of a runaway convention, we would have the right to recall them and replace them with somebody willing to follow their oath of office as a delegate. It would also be a criminal offense to violate your term of your oath as a delegate to the convention to veer on to other topics. So I think that addressed some of the fears of some of the opposition to this. Mr. Chairman, I'm happy to take any questions that you or the committee may have.
The Minority Leader, Ms. Abrams.
Thank you, Mr. Chairman. Senator Kauser, can you where in the legislation does it create a criminal offense?
Okay, do you have it in front of you?
I do. I'm looking at SB 206.
Line 55 on page 2, a violation of the oath is subject to provisions of Code Section 1610(1). That is the criminal statute for violation of your oath of office.
And can you speak to what the penalty is for violating this?
It is a felony offense. It's 1 to 5 years.
Thank you.
Thank you.
Thank you, Mr. Chairman.
I'm going to do again out of order there, Ms. Let's see, we've got is it 794, Ms. Braddock? All right, do 794 now.
Thank you, Mr. Chairman and members of the committee. I bring before you House Bill 794, which is a compact among the states to call for an Article 5 convention and get the federal government to live under a balanced budget and limit their ability to raise the debt ceiling. And it is compact language that's agreed upon in the states, and then it's ratified at the convention by an up or down vote. And it talks about the delegate selection process and everything on the front end. So there's no chance of a runaway convention. It has a lot of mechanisms that will shut the convention down, and I would appreciate your favorable consideration.
Ms. Abrams.
Thank you, Mr. Chairman. Representative Braddock, can I direct your attention to lines 412 through 422 of your bill?
Lines 12 through what?
412 through 422.
Oh, 412. Okay, hold on.
Under the terms of this compact, any Georgia citizen who participated would be subject to trial in the Northern District of Texas. Can you speak to why we would allow Georgia citizens to be tried under Texas law?
The commission that spins up as a result of this bill, it automatically defines a location for this, but they can change the venue if they feel that's necessary. But they selected a venue on the front end just to go ahead and get things simplified and not have to.
Thank you.
Thank you.
Thank you.
Mr. Atwood.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I bring to you two bills, and my testimony this morning relates to both of them. They're both the products of the same parent. It's House Bill 776, which is about halfway down or so under modified open rule, and also on the back page, House Bill 890, 776 and 890, which is under modified structure. Mr. Chairman, with the permission of the chair and the committee, I would ask that the modified open rule bill, House Bill 776, be placed under modified structure. That was a mistake on my part. I meant to do that. Both of these bills, or the first bill, 776, Mr. Chairman, is very simple. It has the support of the Council of Superior Court Clerks. They're the ones that requested it, as well as the Policy Committee of the Judicial Council of Georgia. And it does two simple things. It removes reference to jury commissioners in the Georgia Code, and it amends authorization so that the Council of Superior Court Clerks can receive data necessary to refine the master jury list. What we do in Georgia, this is a cleanup. Literally both of these are cleanup bills dealing with the Jury Composition Act that we passed back in 2011, very voluminous bill. And what that bill did is allowed for master lists to be compiled to do away with essentially what we used to use, a system called forced balancing, where we only chose black, white, male, female, and it was dangerously close to being ruled unconstitutional. That's cleanup language there. Under House Bill 890, this was previous Georgia language under Code Section 151621, and it put back in place what was previously there and inadvertently struck. And it adds, in all counties in the state where the sheriff is paid a salary only, this code section shall apply so as for fees are charged. And what that means is that the fees are collected by the sheriff but deposited and turned over to the county treasurer and the fiscal officer of the county. They're doing that right now. It just puts it back into law, and it was inadvertently struck out. Neither of these bills had any negative testimony whatsoever. With that, Mr. Chairman, I'll yield for questions.
No questions. Thank you.
Thank you, Mr. Chairman. Thank you, members of the committee.
Mr. Tanner.
Thank you, Mr. Chairman. I come to ask for HB 838. It's under modified open halfway down on the front page, 838. This bill would make it a violation under Title 16 for a person to knowingly and without the consent of another person who's depicted in a photograph that's nude or sexually explicit conduct to post that electronically without their consent. The first offense would be a misdemeanor. Second offense would be a felony to do that behavior. I'll be glad to answer any questions, Mr. Chairman.
Any questions? Thank you.
Thank you.
Ms. Underman.
Good morning, Mr. Chairman and members of the committee. I appreciate being here this morning. I'm asking you to look at the modified open rule on page 1 at the bottom of the page. There's two Senate bills, Senate Bill 291 and Senate Bill 292. These are companion bills that I appreciate Chairman Benton and Chairman Cooper. For the past about 12 months, we have served on the Alzheimer's Task Force. There's about 75 members of that task force. We've met all over the state of Georgia, and these two bills are a recommendation of that task force. The first one, Senate Bill 291, is the reorganization of the Georgia Aging Division of the Department of Human Services. And the second one is a disease registry where we will calculate and keep statistics on folks in the state of Georgia who have Alzheimer's and related dementia.
Are there questions? Thank you.
Thank you very much.
Wait a sec. I'm sorry.
Do you have a question?
Yeah. Thanks for bringing the bill. What are the costs of these two?
The cost of the first one is zero, that it didn't have a fiscal note, and the disease registry will be located in the Department of Public Health, and there's no cost either. They have a person they're going to assign to that.
Thank you.
Thank you very much.
Ms. Jones.
Thank you, Chair. Members of the committee, I present to you HB 833 under Open Modified on the top of the first page. It's a very simple bill that simply changes a term throughout the code from slum to blight. Blight is the more modern federally used term for federal grant dollars. There's no other major changes other than the use of the word slum to blight, and the problem we're fixing was brought to us by the Douglas County Commission because they wanted to be able to grow their communities without having to declare it a slum. I'll take any questions.
No questions.
Thank you.
Ms. Clark.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. I bring for your consideration the committee substitute to House Bill 834, and this bill would repeal the Georgia Code, and this would permit the sale of school bonds on any election date. Repealing this code, our county and several other counties all of a sudden have gotten into the population bracket where the code changed and they were no longer able to operate the way they did before. This would repeal it and allow all counties to operate as they did before with bonds.
Thank you.
Thank you, sir.
Big Mouth Orange, come on down.
Mr. Chairman, it's always good to be back where I was house trained, but not broken. Ladies and gentlemen, I bring you Senate Bill 128. It's the fourth from the bottom under Modified Open. This deals with marriage and family therapy, the specialty. We're adding the word diagnose in the bill. Right now they're allowed to evaluate, treat emotional and mental problems. The reason we've got to add the word diagnose, the Department of Infinite Wisdom, when we did this for the social workers, decided that in order to be compensated for doing their services, you have to have somebody diagnosed. Well, I don't know how you treat somebody and then not evaluate them. By the way, the word diagnose appears in about 10 different specialties, including chiropractor. And one day the escalators weren't working, and on the sign it said, closed until we diagnose the problem. So, again, I ask for your favorable consideration, and I'd be happy to answer any questions.
Mr. Hamilton.
Thank you, Mr. Chairman. To the gentleman, seemed like I remember either this same or similar bill last year, and there was some, I just remember some confusion. What was the status of this bill last year? Was this bill brought forward last year?
We had this bill last year, my memory serves me as a fact, we didn't get it out of the House. MAG objected to the bill initially. They came to the hearings this year, and they couldn't voice any objection. They just objected. Of course, they object to chiropractors diagnosing too, so they didn't really have any argument, and that was it. And I think it passed unanimously out of committee and everything else.
Okay, so as far as you...
I don't know of any issues with it.
I don't remember it either, but I remember us talking about it and it not being passed, and I just trying to recall whether there was an issue or it was a timing issue.
It might have been tried to attach to another bill, maybe that's the reason. Germaneness seems to be a problem sometimes.
Oh, God.
Thank you, Mr. Chairman. Always nice to be with you.
Yes, I'm just glad to see you again, Mr. Miller. It's unbelievable. Mr. Turner.
Thank you, Mr. Chairman, members of the committee. I bring for you House Bill 436, which deals with allowing the General Assembly through local legislation to establish durational residency requirements by district for municipal and county commissioners. This does not mandate it. It simply allows it, and without this tweak, there would be a conflict between local law and OCGA in certain counties or cities and the OCGA would take precedence, thus nullifying the local durational requirements in those elections. Since the OCGA states the only residency requirement for county commissioners, as an example, is that they live in the county for 12 months, a candidate can live in the county for a year but then move to a different district just before qualifying. And that may work for some counties, but other counties may need that flexibility through local legislation to repair that. So I'd ask for your favorable consideration.
Who's number 5? Okay, thank you.
Thank you.
Okay, members. Mr. Lindsay.
Thank you, Mr. Chairman. Bring before the committee House Bill 804. Georgia is one of the few states in the country that require a child over the age of 10 to have to testify live in front of the individual who either sexually or physically abused them. What this bill will simply do is raise the age up to 18. It's up to the discretion of the judge based on certain factors, but it allows the judge at his discretion to allow the child to testify remotely.
Any questions? Okay. Ms. Abrams.
Thank you, Mr. Chairman. I'd like to ask for consideration for HB 833 and HB 750.
What was the last one?
750.
Okay. Mr. Weldon.
Thank you, Mr. Chairman. I'd like to request House Bill 776 on modified open rule, and then on the second page under modified structured rule, House Bill 890.
Ms. Drenner.
Thank you, Mr. Chairman. I'd like to go on record in supporting the city today, HB 704.
Okay. Mr. Smyrie. Were you laying down over there? I didn't know. Okay, everybody's had a chance. That's it. Let's see. All right, this is the calendar for tomorrow. You were sleeping. Go ahead.
Thank you, Mr. Chairman. I'd like to ask for House Bill 899. The truly bad people in our state.
Wait a second, Sharon. Hold on. Now try it again. I can't hear you.
Thank you, sir. I'd like to ask for House Bill 899. The truly bad people in our state have found it very lucrative to prey on the elderly, especially by starting unlicensed personal care homes, and they think a misdemeanor is a gnat, and this would raise the penalty on first offense to a felony, and the judge would have the right to change that if they wanted to. Thank you.
All right, now we'll go. All right, modified open. HB 704. Any opposition? Okay, it's on. Under modified open, HB 749. It's on. Modified open, HB 770. Any opposition? So, modified open, HB 838. Any opposition? So, modified open, HB 911. It's on. Modified structure. HB 790. Any opposition? Modified structure, HB 890. Any opposition? Modified structure, HB 891. Ms. Abrams.
Ask for a one-day hold so I can confer with the author.
Yes.
Thank you.
We'll hold that one to Friday. Modified structure, HB 979. Any opposition? All those in favor signify by aye. Aye. Those opposed, same sign. It's on.
Day hold on this. We have a local ad that's running right now to solve this problem. And I did not want to belabor the point with Representative Jacobs.
I'm pretty liberal with that thing, except on certain issues, but it's my understanding that the time is of the essence on this thing to get it done so that the people of DeKalb County won't have a problem. And I'd much rather see it go tomorrow and get it out there. If it's modified structure, it can't be messed with.
Mr. Chairman.
Yes.
Mr. Chairman, just an observation that because of the time constraint of the general bill, it doesn't prevent a local bill from operating on a parallel track, and then as the session progresses, as the issue progresses, that it won't do any harm to have parallel track bills going. Just an observation.
With that said, I'm gonna leave it on there. All right. Modified structure, HR 1215. Did somebody move? Any objection? All those in favor signify by aye. Opposed? It's on. Under modified structure, SB 206. Any objection? All those in favor signify by aye. Those opposed? It's on. Yes, Mr. Gollett.
Just for clarity's sake, so the clerk can be aware, with the consent of the author, Mr. Welch will be handling SB 206 on the floor tomorrow. Thank you.
Okay, under structured, HB 794, do I hear move? Any objection? All those who object signify by aye. All those who are for it signify by aye. Ah, there you go. I thought maybe I'd catch you. I caught two up here with me. Okay, it's on. Under structured, SR 371. Any objection? All those opposed, raise your hand. All those for, raise your hand. It's on. That's it.